My name is Tionna Dolin. I'm an associate attorney with Estelle and Kennedy, a professional law corporation. We are a private firm with offices in Upland and Los Angeles, and we also have a satellite office in Orange County where we can meet with clients if needed. We do a large variety of practice areas, but I'm going to be talking to you today about probate and estate planning. Okay. So if you have a will, probate is a process where the court supervises the transfer of those assets to the beneficiaries listed in the will. So just because you have a will doesn't mean you won't end up in probate court. You actually do have to go through probate when you have a will. This process begins with the executor, who is the person named in the will to administer the estate. And the executor files a petition seeking appointment from the judge. So their actions as an executor are not automatic. They do need court approval to proceed as the administrator. After the court approves appointment, the executor takes charge of the assets, pays the debts, and distributes the rest of the estate to the beneficiaries listed in the will through court approval. So each stage is approved by the court before the actions are taken, or sometimes after the actions are taken, the court basically makes sure that everything's done properly before the distribution occurs to the beneficiaries at the end. So the process is overseen, and there's a lot of court filings that take place, and there are court fees that go along with that process. Okay. When someone dies without a will, probate's initiated by a relative or an interested person. Similarly, the court has to approve an administrator. But in this case, because there's not an executor listed in a will, the court determines who the administrator will be. The court also is going to determine who the legal heirs are. So there's a court process to determine that, and the distribution will occur to those heirs, and that process, again, is supervised by the court. Also, an administrator is sometimes referred to as a personal representative. So there are advantages to probate court. Although it is a lengthy process, the court has experience resolving disputes among beneficiaries. So that is one advantage of probate court. They have a set structure and set rules to determine what the outcome will be. And sometimes beneficiaries need to be protected from personal representatives who take advantage of their position, so that oversight can be helpful for the beneficiaries. So, as you probably can tell, there are also some disadvantages to probate. Your estate plan and assets become part of the public record. Another disadvantage is that probate proceedings usually take a lot longer than administration of the trust. Also, court fees can be really expensive along with legal fees, so the whole process can become a lot more expensive. It's really important to discuss the pros and cons of probate and estate planning with an experienced estate planning attorney, because there are just different disadvantages and advantages to each option. Avoiding probate through estate planning is by developing a detailed estate plan that addresses all of your concerns, and there are a variety of things that you may be concerned about. So an estate plan can be crafted that will meet all of your needs. Estate planning is a plan not only for your assets, but also for your care should you become unable to care for yourself. This plan involves whatever you want. It could be your family, your friends, or even charities that you'd like to give your assets to at some point in your life or after your life. So you need to start by thinking about what are the various types of assets that you own. Okay, so estate planning gives you control over the following: how your assets should be managed during your life, who should manage your assets if you cannot, when and if your assets should be distributed during your life, when and who should receive your assets after your death, and who should make healthcare decisions on your behalf, even what they should decide at the time that those circumstances arise. I'm going too fast. So these are the important questions that you need to consider when you're starting to think about creating an estate plan. What are my assets and what is their approximate value? Whom do I want to receive the assets and when? Who should manage the assets if I cannot? Who should be responsible for taking care of my minor children if I cannot? Who should make decisions on my behalf concerning my care and welfare if I cannot care for myself? And what do I want done with my remains? And where do I want to be laid to rest? So your assets are basically everything you own. This is bank accounts, real estate, stocks, bonds, furniture, cars, jewelry, life insurance, retirement plans, and even assets that are owed to you, such as a tax refund. So these are all of the things you need to start thinking about and considering before making your estate plan. The value of your estate is the fair market value of your assets minus your debts. The value of your estate affects what your estate will be taxed after your death and whether beneficiaries will pay capital gains taxes on the distributions that they receive. It's important to ensure that enough resources are available to pay these taxes in advance so that your beneficiaries are not left in a difficult situation where they owe money. Estate planning procedure. So you need to create a will and a trust if you want to create an estate plan that addresses all of your assets. And then also a financial durable power of attorney. And this basically, I'll go into it in more detail in a moment, but it would help your family or friends who may be responsible for your care if something were to happen to you and you couldn't make healthcare decisions for yourself or make financial decisions for yourself.
Excuse me, you have mentioned a will and a trust.
I will be going into that.
Okay.
Yeah. Okay. And then you would also need to create a living will or medical directive, which is basically, I'll go into it in more detail as well, but it's your method of communicating with doctors if you're incapacitated. And then finally, you would want to make final arrangements so that your family is not in a dire situation and needing to make these arrangements on your behalf at a time that's already really stressful. So a will is a legal document that sets out who or what charity should receive your assets. It states who will be in charge of managing your estate, paying your debts, the probate expenses and taxes, and distributing the remainder of your assets after those debts are paid off. And it names guardians if you have minor children, and you should pass while having minor children. There are exceptions. If you have assets that already have listed beneficiaries, those do not pass through a will, and they're distributed directly. So that happens automatically with an affidavit of death or death certificate. And these assets include a life insurance policy, an IRA, retirement plan, an annuity. So there's usually a beneficiary already listed on that asset, and that asset transfers automatically, not through the will. Some of the other exceptions to a will are assets that are co-owned or jointly held. Those assets also pass automatically at death, and assets also that are an exception to a will are assets that you transfer to your trust. So if you own a house, and on the deed to your house, you're a joint tenant. It's common when you own a house with your spouse. On your death, that would pass automatically to your spouse, not through the trust or will. Okay, so a commonly used type of trust is the revocable living trust. I'm going to talk to you about those. Okay, so assets are put into the trust, which is managed for your benefit during your lifetime, and then distributed to the beneficiaries after your death without court supervision. So this is the method that you can use to avoid the probate process. It leaves you in control of your assets during your lifetime, so you name yourself as the trustee during your life, and then you're able to make decisions that benefit yourself and remain in control of your assets. Revocable also means that you can cancel the trust during your lifetime. And as long as you're competent. So once something happens where if you were to become incapacitated or unable to make decisions on your own behalf, then the trust would also become irrevocable, meaning you can't cancel it. You name a successor trustee, and this is the person that would take over the trust at the time that you become incapacitated or that you pass. So, pertaining to your question, there still remains the need for a will, and this is a pour-over will. The will addresses the assets that are not transferred to the trust. So it's common that you're going to transfer your real property, maybe some bank accounts, but you probably have other assets that are the residue of your estate, and they could be too various to list out in a trust. So those remaining assets will be part of your pour-over will, and there will be a beneficiary of the pour-over will who receives those assets. They might be the same person as listed in the trust, but both documents are needed. And the trust can create the pour-over will by referring to it.
Excuse me, and that would be like listing like art or jewelry?
Sure, yeah, but you can make those specific requests in your will, but you can also transfer them to the trust. So a qualified estate planning attorney is necessary in order to ensure that your plan assesses all of your assets and all of your care needs. There might be some things that you haven't considered, and your estate planning attorney might direct your attention to those things. Finally, choosing a trustee is really important. Again, a trust is not overseen by a court, and because of that, sometimes trustees take advantage, and you have to protect your beneficiaries by choosing a good trustee. Okay, so just like a trust can create a will can also create a trust. If you only have a will, the executor will still have to go through the probate process. So the will does not protect you from having to go through probate court, and the administrator again has to seek the court's approval to proceed. The first thing, they'll have to authenticate your will. So the court will take a look at your will and ensure that it is in fact authentic. You'll need the original will. They'll appoint the executor as the administrator, pay your debts, pay your taxes, identify your heirs, and then they'll receive court approval before distributing the assets to the named beneficiary, and the court makes sure that the distribution matches your will. Another document that is part of your estate planning is the financial power of attorney. This is the second step to creating your estate plan, and this helps your friends or family to have to avoid conservatorship proceedings. Those apply if you become incapacitated and somebody needs to make financial decisions for you or decisions about your medical care. This isn't automatic. They do have to go to the court, and conservatorships can be very complicated. You have to file yearly accountings, and it can get very expensive. To consider is that the court might not appoint the person that you want to make these decisions about your finances or about your medical care. So it's really important that you do this power of attorney in advance so that the person making the decisions is the person that you want to be making these decisions. The third step is creating a living will or medical directive, and as I noted, that's your method of communicating with your doctor if you're incapacitated. So it speaks to things like whether or not you would want to be revived, whether you would want to be put on life support. That document would probably be in possession of the person with power of attorney, and then they'll know what decisions you wanted them to make in those circumstances. The fourth step, the last step, is making final arrangements. This really helps out your loved ones. If you do this in advance, it will save your estate money, it will save your loved one's stress and anguish at a really difficult time. It lowers the cost because if you shop ahead of time, the rates are usually a lot lower than if your family members are trying to do this at the last minute. And you can decide how you want to be commemorated. So there is no estate tax for the assets that are left to your spouse or a charitable organization. All the other distributions that altogether add up to $5.43 million or more, there'll be a 40% estate tax.
40%?
40%. So you can save money by planning ahead. So while you're living, you can give away at this point up to $14,000 per person per year without paying a gift tax. Also, no gift tax applies if you pay someone's school tuition or their medical bills directly to the institution. So if you have a grandchild that's in college, you can pay those tuition bills and you won't be charged with the gift tax. Gains tax, then the debt is going to be part of the calculation. Also, there's going to be a variety of other factors I'm about to get into that have to do with how the asset is held, whether you have it in joint tenancy. Okay, so I guess we're back on. If you have another question after I've gone through everything, we'll address it at the end. Okay. So there are advantages and disadvantages depending on how the asset is held. You can hold an asset in joint tenancy with the right of survivorship. And again, I'm speaking to California law. You can hold it as tenants in common, tenancy by the entirety, or as community property. This is when you're holding an asset with another person. Okay, so when I'm talking about assets, I'm not only referring to real estate. This also includes bank accounts, brokerage accounts, and other assets that you can hold in joint tenancy. This is really common when a husband and wife are listed on a deed. There are risks and advantages to holding a piece of property in joint tenancy. It does avoid the delay and the cost of probate. Some further disadvantages are that there's no step up in basis, so the capital gains tax will likely be significantly higher. This basically means that the house will be evaluated at its value at the purchase price, not at the time you receive the asset. So for purposes of calculating capital gains taxes, it'll be much higher. I'll get into it in a little more detail. There's also a loss of the estate tax protection, and the joint tenant can transfer the asset without permission of the other joint tenants, and it exposes the asset to creditors of the other joint tenant. Further disadvantages, joint tenancy disinherits all of the other heirs because the whole asset goes to the other joint tenant automatically. A gift tax can result that's calculated half of the value of the property. If it's more than $14,000, there'll be a gift tax. Joint tenancy controls over the provisions of a will or trust. So if you own an asset in joint tenancy and your joint tenant isn't the person you intended to inherit the property, then you have a problem, even if your will or trust says something different. Because of the advantage of avoiding probate, a lot of people put their asset into joint tenancy with their child. There are a lot of risks with that. The asset can be exposed to lawsuits, and you can lose your property if there's a judgment entered against that person.
Thank you.
Again, there's no step up in basis, so the child will pay higher capital gains taxes if they go to sell the house, especially if the house has appreciated since you purchased it. The basis value, again, will remain the purchase price. If the property were to pass through a trust, there would be a step up in basis value to the fair market value at the time of distribution when used to calculate capital gains taxes. So let's say you bought your house for $25,000 a long time ago, and then now your house is worth $200,000. If If you transfer it through joint tenancy, the basis value is going to be $25,000, and if your child sells the house for $210,000, not great at math, but that's about $85,000 they have to pay capital gains taxes. But if the fair market value is $200,000, you don't pass it through joint tenancy, you pass it through the trust, then that's only $10,000 they have to pay capital gains tax on. So there can be a huge difference depending on whether your house has appreciated in value since you purchased it. So each person's estate benefits from a tax exemption that's up to $5.43 million. However, if the estate passes through joint tenancy, one exemption is lost. So basically, two estates become one when the house passes through joint tenancy, and where you would have had two exemptions up to $5.43 million, you now only have one. So if the combined estate of a couple exceeds $5.43 million, there'll be a 40% estate tax. I don't know if that was that clear, but the way it will play out is when the first person passes, the house will go to the joint tenant, and then now that two estates have become one, and then when the second joint tenant passes, that's when that deduction that would have been $10 million plus, because it was two people, is now only going to be $5 million. For the person, let's say you have a couple and they have a child, now when the child inherits it, the estate tax of 40% will apply if the combined assets of their parents would now adds up to more than $5.43 million. And that's not just the house, just the whole estate.
But now if the husband dies and it goes to the wife, would the wife have to be responsible for, if it's at that $5 million mark, that 40%?
Not at that time.
Not at that time.
Still, the living trust is still.
This is in this, when I'm speaking to the situation where you're not using a trust, when you're using joint tenancy as an estate planning tool.
Okay, well, they're joint tenant on their properties.
Then that's what will apply. As I said, joint tenancy trumps a trust or will. So that the asset will pass through the joint tenancy laws, not the trust laws. If you want your asset to pass through the trust, then you're going to need to change your deed, and you're going to need to hold the property in a different form of title. So I'm going to be giving a little more into that as well.
They're all packing up right now.
Okay.
Yeah, it's really packed up. But they're already over there.
Another risk of joint tenancy is that the joint tenant will immediately have sole ownership of the asset, and the person doesn't have to share this asset with other beneficiaries or honor any wishes that you may have expressed to this person. However, a living trust offers the following protections. It protects the estate from creditors of your beneficiaries. It avoids probate. You maintain the stepped-up basis for the purposes of calculating the capital gains tax. You preserve both federal tax exemptions, so when you have a couple like that, it would be $5.43 million plus $5.43 million for the whole estate. And then your wishes are protected. Okay, so that you fully understand the options of taking a title to a piece of property with another person, I'm going to lay out the basic features of each. Joint tenants automatically inherit property. Each tenant must have acquired or become vested with the title at the same time.
You're out of sync with your slides here. That was the last slide. There you go.
Thank you. Each tenant must have acquired title by the same instrument or deed, so you can't just put someone as a joint tenant automatically. You can't just give them a deed for half of your value of your property. You have to create a new deed that you basically are deeding the property to yourself and the joint tenant, because you have to take it by the same instrument. Each tenant owns an equal and undivided interest, a right to possess the whole property, a right of survivorship, so that's the automatic inheritance of the property, and it cannot be transferred by a will or a trust. A tenancy in common, the tenants have a separate but undivided interest in the property, and the ownership interest can be varying in proportion. So this is something you can use to reflect investment if you and the other person invest different amounts into the property. In a tenancy in common, you can have a different proportion of interest in the property. So a lot of people who invest in real estate are going to use this. So this can also be transferred by a will, this form of ownership, because there's no right of survivorship. This is good if you have children from a prior marriage that you want to inherit your interest, because the property won't automatically go to your spouse, they can inherit your interest. So you would want to own that as a tenancy in common in order to protect your children. They have an equal right to possession, but there are always risks that co-tenants won't come to a consensus about different issues that arise with the property, improvements, things like that, and the co-tenants can sell off their interests. So then you might end up owning an asset with someone else, any person. So just to talk to you a little bit about investments and real estate, under the Internal Revenue Code section 1031, when there's a like-kind exchange of property, the capital gains tax is referred. This is a little bit complicated to get into right now, but basically because tenancy in common is alienable, meaning you can sell it off, and there's a tax benefit, which is the like-kind exchange, and because it can be owned in varying proportions, a lot of property investors buy property in this form. If you want to know, I might get a little bit more into the like-kind 1031 thing, but basically, if you exchange an investment property for an investment property, let's say you sell off one interest to just buy interest in another, let's say it's apartment buildings. That's the same kind of asset, you're just changing your investment, that's a like-kind exchange. If you sell your interest in an apartment building and then you go buy your personal residence, that's not a like-kind exchange. So if you're just changing your business investment, then you can defer the capital gains tax. And you won't pay taxes on the money you make on that transaction. Okay, tenancy by the entirety is for married couples only. They enjoy the property by the entirety, and the surviving spouse inherits the property automatically. Neither spouse can transfer or convey their interest to a third person without the consent of the other spouse. This is the main difference between tenancy by the entirety and joint tenancy. The title converts to tenancy in common automatically on divorce. Okay, so the community property states are Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin. Community property is deemed as co-owned by spouses regardless of how it was purchased until separation or divorce. This is getting into family law, but the separation date is the important date, and that there's a variety of factors that apply to determining what that date is. It's not just when you started fighting. So each state sets out its own community property laws. I'm going to be referring to California law in general. Generally, any property acquired during the marriage while living in a community property state is community property, and it's jointly owned by the spouses. But there are exceptions. Property received by gift or inheritance is not community property, even if received during the marriage. Property purchased with separate property assets or income from a separate property asset, so long as the assets are not commingled with community property, remain separate property. And also if another entity owns the property, in actuality, then it might not be community property. Okay, so I'm sure I've raised probably more questions than you had in the beginning. But I hope you understand a little bit more about what your questions mean, or you can ask more educated questions at this point. We do a 15-minute free consultation at our firm, so if you take down or you have on your handout either number, you can give us a call, and we'll talk with you about your questions and let you know whether we can help you further by setting up an appointment. We have qualified attorneys to do estate plans if you're interested in starting any of these documents or even just looking over what you have already.